Hello and welcome to the latest in a series of Kuits briefings from Kuits solicitors in Manchester. These briefings are on topics and subjects of interest to commercial clients of this firm and commercial businesses and clients everywhere. Today I'm pleased to be joined by Kevin McKenna, who heads the employment team here at Kuits. Kevin, hello. Obviously, jobs is a central topic at the moment, arising out of COVID-19 and the impact on the economy. I know you were very exercised in the early stages of lockdown in dealing with the furlough arrangements, which have widely been accredited of maintaining jobs in the economy. But we're now moving into a new phase, aren't we?
I think that's right. I think that gave opportunities for business to take a pause, took lots of pressure off businesses from making some of those very difficult decisions. But I think the time for businesses to make those difficult decisions is now looming once again, as you say, as the scheme comes to an end and tapers down to its conclusion in October. And so we are now talking to businesses much more about their restructuring, about sometimes changing terms and conditions, but also we're seeing a lot more inquiries about, as you might expect, about redundancies.
Yeah, and assuming the furlough scheme doesn't get extended in some way, is it your sense that these are going to be widespread as we're reading in the media?
I think that's right. I think that on the whole, employers have been compassionate where they can be about trying to keep employees in work to benefit from the scheme. But I think it seems inevitable that won't be able to continue, and that redundancies will be necessary, and businesses need to think about the timing of that so that they get their ducks in a row, get their process in order, and begin to plan that.
And how long in advance of a redundancy program do you think business owners are wise to start the planning process?
Well, that planning or the timing of the process will be partly dictated by the numbers involved. So if you're making redundant between 20 and 99 employees, then you're going to have a 30-day minimum consultation period. And if it's more than that, it's a 45-day consultation period. Even if it's smaller scale redundancies, there is an obligation to consult meaningfully with employees. So that's still going to take time, but so will the planning for the business to get that in place. So as always with these things, the more planning that the business put in, the better.
And effectively then, I get the sense that you're helping employers navigate their way through a minefield.
I think that's right. I think we're in a situation where I always think about redundancies in one sense as being the sorts of situations where employers, if they get it right, they should never really then be at risk of the added pain of potential tribunals. And that's one of the hard elements of this, is that clearly there are many businesses that are suffering where financials are tight. And the last thing, really, I suppose you want to do is to then bring on a potential dispute as a result of that. And any dismissal can be a minefield. Redundancy dismissals, no less so. But I'm also finding that you could be in business for a long period of time and perhaps not have had to deal with redundancies since the last recession in 2008. So there are lots of experienced managers, lots of experienced HR professionals out there who still may not have been through a redundancy process. And I think that that's where we've been able to and can add value.
And what are the implications if you get it wrong?
Well, you've got the potential for unfair dismissal claims for employees that have got more than 2 years service. You've got lots of employees who will have less than 2 years service, but still may feel that they've been singled out for termination for other reasons. Whether that's true or not, sometimes there will be employees, and we've come across that recently, who will say, I think that the reason that I've been singled out in this is because I'm a part-time worker It's because I'm the oldest person in the out of the group of employees. So there's potential for discrimination claims as well as unfair dismissal claims. There's the potential for bad publicity because tribunal decisions get published now on the internet on a portal, so they're searchable. And then there are the morale implications for businesses going forward at your very difficult time when businesses are talking to me about saying we want people shoulder to the wheel to help us recover. That's not a time when you really want to be taking significant dips in morale because you've handled the process badly or shoddily or really just misunderstood how you should go about things. And that's an area where I think employers do fall foul, that they very often make their mind up too quickly about what it should all look like at the end without going through the proper steps. So there are lots of traps for the unwary.
And I'm guessing also that even employers who make their decisions on perfectly appropriate grounds fall over because they don't document those decisions, or can't evidence those decisions properly. Is that right?
That's right. It's absolutely right. And I suppose it's often in the nature, particularly of lots of the clients that we would deal with, of entrepreneurial businesses that need to make decisions and move on and get on with things. They will be perfectly rational about lots of the reasoning, but you do need to stop and think about pooling. What can you contractually require people to do? You need to think about selection criteria. That needs to be done appropriately by the right people. There needs to be checks and balances for that. You need to make sure that you're not including factors that you shouldn't and that would be unlawful. You need to properly consider alternatives. You need to genuinely consult, even though you might think, I think I already know how this should look like at the end. You do need to stop and pause and think and go through those proper processes. Yeah. And
I know you've applied a lot of thought to this in the period, in the COVID period in particular. And I understand you've launched an insurance-backed package for employers which can help them get the advice they need, but also crucially give them financial backing in the event of a challenge. How does that work?
So the start of this actually dates back to the last recession, when going through lots of redundancy processes. It was a very similar sort of situation where, again, you would be working with businesses, experienced businesses, but perhaps not lots of experience in the process. And I tended to always to think that redundancy in this kind of climate is something that employers should never get wrong. You should never find yourself in a tribunal being challenged or losing a tribunal in relation to these sorts of claims. So we looked at it from the point of view of the process and building that process and using our experience of getting through these processes to say, we can help businesses through that. We can fix the fee because, broadly speaking, once we know what's involved, once we know the numbers of employees involved and the pools that might be involved or the number of sites, then we can work out a fixed fee for clients and say, we know what we can deliver to help you through the process from beginning to end. We can sit through meetings if need be. We can deal with the questions, sometimes the difficult questions that employees might ask throughout that process. And then we can speak to insurers, and we've coupled with teamed with an insurer to say, if we've worked through this process, then we will have mitigated that risk. Will you insure that process because it's got our stamp of approval, so that if there are any claims that arise from it, then not only are the legal costs of handling those claims covered by the insurer, but any award that comes from it. And so that's what we've put together, a fixed price package so that the employer in times of financial difficulty has got the certainty of saying, that's how much it's going to cost me, even if it goes wrong, or even if maybe it won't go wrong. Maybe employees will think, well, my only option is to bring a claim. You've got to look at it from the employee's perspective. If you've been dismissed on the grounds of redundancy, you may feel that your only option, if you can't get alternative work, is to pursue a claim. You might think that there's something that you would gain out of it. And so this covers even those situations. So even though the claims might be low in their prospects of success for the employee, then we're there throughout the process and everything that comes after it.
So a real hand-holding exercise, and crucially, for employers, a fixed fee.
Yeah.
Okay. I know a lot of employers wonder often why use a lawyer, and many use HR consultants, and there's a wide body of HR consultants out there. What's the advantage of using a lawyer in this situation?
Well, I think there's one key advantage to using a lawyer, and that's that we are able to offer legal professional privilege, which effectively gives confidentiality to the communications that clients have with us about a process. As I mentioned before, lots of employers will think, I know who I want to go. And any communications like that perhaps with HR consultants won't benefit from legal professional privilege. If you are a claimant in an unfair dismissal claim or in a discrimination claim, then actually potentially that is solid gold to your opponent. Some of the unwary conversations that may be had or documents that might be produced that don't have that protection. So that's not to say that there aren't perfectly professional HR consultants out there who are experienced and able to do these things. But what they can't help you with is where the client has said something or those conversations get perhaps a little bit out of hand, and evidence, valuable evidence for your opponent is created in that way. I think that's a huge factor. Of course, there is the factor that we can take clients from the beginning of the process. We definitively have skin in the game to take you from the very beginning, from the announcement, and we would be there right to the very end if it happened where you found yourself in an employment tribunal and the judge is giving their determination.
And I'm guessing, by the way, that the point on privilege applies equally to internal communications within employer companies. Is that right?
That's right. That's absolutely right. Yeah. So even if you're talking to your internal HR department, then again, you're producing documentary evidence. And it's a really powerful tool for employees in that situation to be able to make their data subject access requests. They now don't have to pay anything to make that request, to get any emails that might have their name on them. Sometimes that's how cases get unpicked.
So the time to pick the phone up is when it begins to look like, and literally begins to look like, you might have to make redundancies in your company. That's the time to pick up the phone to someone like you. Is that the case?
Yeah. I mean, it's a false economy to wait until you hit a bump in the road and think it's only at that stage that I'll get lawyers involved. It may be that too much water has gone under the bridge by then, and that you can be trying to retrieve something that's already lost.
Kevin, that's very helpful, and thank you very much indeed. Your details are going to come up at the end of this presentation, but for now, until the next Kuits briefing, thank you.